What's up? I'm Dan Fredenberg, and this is Figure It Out. I'm joined today with the patent Baron, Baron Lesperance. Is that how you pronounce your last name?
Yes, correct.
All right, awesome, awesome. So you focus on intellectual property, and I've got something fun for anybody who's been following me in my commercial real estate circles because I want to talk about fair use. So let's talk about the part that's applicable to pretty much anybody on the internet first, which is the use of memes. Let's start with memes, and then we'll go to the film sample that you were talking about. So with a meme, there are some that have celebrities in them, and then there are others where it's just a person who just happened to become meme royalty. I interviewed Hide the Pain Harold, if you know who he is. But there's also like Bad Luck Brian would be another example of someone where, the recognizability is there, but who they are outside that, you don't really know. So if you have a business and you're trying to build your social media presence and you're tempted to use a meme, what's the advice that you'd recommend as not the audience's lawyer, but just somebody who should really talk to their own lawyer and blah, blah, blah?
Right, right. Well, it does depend a bit too on where you are. So, I think that's, one thing to mention, whether in the United States or if you're in Canada or other countries. So, the laws do vary wherever you happen to be. And also to wherever these videos will be posted or hosted, say if it's on YouTube or your own website or Facebook. So, they all have different regulations and, it's good to investigate those. That's a good, safe, lawyerly answer, right? So, but you need to be careful when you're dealing with famous people and their images and things, because obviously, there's copyrights involved, and they have agencies that monitor and look for these things and look for people that are using them without permission, because it's a slippery slope. If they don't do this, it'll just become more common and it won't be respected, and the whole value of that will be lost. And so that's good and bad, but that's just kind of the way it is. But if you're doing a meme for, let's say, a cat or some other thing, something else, or something that doesn't include a famous person, then probably have a bit more leeway. But theoretically, kind of all of those things are, original works, and, someone could, copyright that, and it could become something that becomes really valuable and protectable. So, it's kind of a case by case thing. And, it's something that, if you want to necessarily avoid problems, it's good to, talk to your IP professional beforehand, just to make sure, where things are at that particular date and time.
Mm-hmm. All right, and one thing that we discussed this before is because of my background in music, I was aware of this stuff for quite some time. But one thing that crossed my mind when it comes to fair use in general was, from what I understand, the process from you're doing something that on, like, let's just say that if it did go to court, then you'd end up losing. So first, that's step one. This is the last step over here, like some sort of consequences happen as a result. But on that first step, from what I understand, before you get to court, if you're actually going to win, you should be able to provide proof to the judge that you as the copyright holder, so not the person who's posting the memes in this case, you as the copyright holder actually took some measures to get this settled before you arrived in court, right? Like, is that something that's real, or is that something that I just assumed?
Well, I think that can happen in certain, situations. And again, it does kind of vary too as to where you are. I think if you're the copyright holder, you would more than likely reach out to someone you think was misusing your copyrighted work, and they may or may not respond. And then, then you have to decide what your next steps are. If you're going to escalate things and then, moving towards a court situation and looking for an injunction, a cease and desist, maybe reaching out to the host of this particular work, let's say if it's YouTube or Facebook, and have that taken down. So that might be a resolution before something came to court. If it's something outside of that, if it's a personal website, if it's material goods and things that are being sold and so forth, and there are other ways to do that, which may involve moving towards a court setting and where you're going before a judge.
And running the risk of boring the crap out of our audience. If we're talking torts, though, in a lawsuit, would they have to prove some sort of damages in order to get a settlement in their, a judgment in their favor, or?
Well, I mean, they would have to show that the copyright was being misused and that person didn't have permission to use it, and there may or may not be actual damages, but it's basically defending that copyright or that trademark, as another example. So like we were talking about, kind of the slippery slope, copyright holders, particularly ones that are commonly misused or misappropriated, then they have to be on their guard, and so they want to maybe nip things in the bud before there are real actual damages, but just to prevent someone from let's say misusing a Disney character, they're on goods or on a website and things like that. Disney's very active in that, and they have to be, because all the you can just imagine, it's pretty easy to imagine people, if they were pretty lax about it, then you might not be so interested in buying authentic Disney goods and products, or viewing some of their authentic movies and animated shows and things like that. So might make them sound to be a bad guy, but again, when you look at what could happen if they didn't enforce and be proactive on it and on the ball, then it could have kind of a different marketplace where maybe consumers wouldn't be that satisfied.
And it's interesting because one thing I found, which really surprised me about, now that I've got into YouTube, I've become a YouTuber, I've got 400, 500 videos, somewhere around that neck of the woods on YouTube. And it seems that the biggest thing that YouTube is concerned about is the music. If you have something that has copyright music on it, it will get flagged, and you'll know almost immediately this video cannot be monetized just because of a few second clip of a song. And the thing that's really interesting about that as well is I've heard that some people are using that trick to basically to stop people from posting political demonstrations, riots and stuff like that. If they start playing popular music, then YouTube won't let it anymore. So it's that little whole strategic mess, it's really quite something, I think. Is there do you have an idea of why? Well, I don't know if you've seen the same thing that I have, but I've just noticed that music is so much more carefully controlled than the video itself. Got any insight on that, or have you seen anything to the contrary?
Right. No, that's really good. I wasn't really aware more on the using it, kind of weaponizing the copyright, if you will. And I think that's an interesting, concept. I've seen it more on the having, music in the background. Let's say I'm a bit of a car guy, so I watch a lot of automotive videos, and I so often see people, if they turn on a car and the radio happens to be on, they immediately dive for the off button to turn the radio off, because there's something playing on the radio that is undoubtedly copyrighted. So they want to avoid that problem. So yeah, I think just music is such a hot topic, going back through the years, Napster and everything in between, right? It's just something that YouTube and just the whole IP entertainment industry is really on high alert for. And I don't think that's going to change, but I do think it's interesting, this weaponizing video, or essentially contaminating video with copyrighted music and making it not playable on a lot of platforms is an interesting, something that certainly wasn't contemplated, but we always say the law trails technology, and this is yet another another example of that.
Right, right. And the thing that's interesting to me, as a musician, like I've got an episodic memory, and it's even more tuned for music. So like there's songs that I've only heard once in my life. It was 20 years ago, and I could write it exactly. Hear the words, hear the melody, all that kind of stuff. And I don't need sheet music to just pick up a guitar and play a song that I've heard well enough. And so I think that makes like the legal situation super duper weird. But there's another thing that I've seen on YouTube with what on the surface appears to be a flagrant misuse of copyright. But what they do is they'll take a song like "Where Are You Now" by Justin Bieber and Skrillex, and then these audio effects guys, they go through all of their synthesizers to try and imitate the sound as closely as humanly possible, well, digitally possible. But YouTube's actually able to tell if it's the same file or not. So if it's a cover, then that's actually okay. But as long as it's not, like note for note, absolutely perfect. And that hits me as kind of odd. So like, I understand the part of it having to be a unique creative work. And it matters that the source content was publicly available, right? Like, does that matter? Like if you go, let's say you go to Snoop Dogg's house and you get an unreleased tape of his tape, you just go a USB key, I guess. And then you go home and then you like rip off the song completely. Well, I guess Snoop Dogg wouldn't have a leg to stand on unless he had some way of proving the date that he created the original. Is that right?
Well, I mean, that's an interesting scenario. So, I think aside from like the theft of the, tape or MP3, thumb drive, whatever, apart from that. So, he could probably show that he had created that at some point, especially more recently with, basically uploading it to this, memory stick and so forth. So, yeah, I mean, that's an interesting, scenario, but I get what you're talking about too with covers and versus, original reproductions of someone else's work. Yes, I mean, you often hear many artists will do covers of other songs, and sometimes they will get permission from that particular artist to say, I'd like to do a cover of this, on a different style or whatever, and they're maybe fine with it. It can depend on the situation. I was talking with someone recently, and they said, "Well, what about Weird Al Yankovic?" And he's kind of created this unique parody songs, right? But he's certainly done a lot of things. He's sold a lot of digital records and things like that over the years. And a lot of artists are really happy about it because they've reached that threshold that he recognizes the popularity of their song to make a parody. But some artists are not, they don't like it, and so there's been situations where that hasn't worked out for him. So, I mean, doing a cover of a song, say in a different style and a different key. I mean, I'm not a musician, but you are. But obviously, there's a lot of ways to and even slightly modifying songs, and there can be problems. I mean, I remember the Ray Parker Jr., Huey Lewis, I Want a New Drug, Ghostbusters lawsuit, quite a few years ago now, but that just stuck in my mind. And, I listened to both of those songs, and, I still have a hard time, figuring out whether that's that really, I don't see it as well. I mean, I'm familiar with both of those songs, and it never clicked to me until, I heard about this lawsuit. And every time I hear it, I still think about it.
Yeah. Well, I think that's an Achilles heel of the entire court system, which is that it relies on expert testimony. And sometimes you get some really crappy experts. And the one that comes to my mind is the Blurred Lines, Robin Thicke case. That one was utterly outrageous because the only thing similar was the tempo and rhythm. And if I had a chance to walk into that courtroom, I'd introduce them to the concept of samba music or rumba music, because there's one rhythm. You're not allowed to use any other rhythms. Okay. So the only consistent thread between, that it was a Marvin Gaye song, right? That they said was a copy. Yeah, it's like it's literally only the drum beat, okay? And it's like, what about electronic dance music? Every single song, it's the same tempo. It's about 80 beats per minute, right? And so I don't know. I thought that was a miscarriage of justice, and I figure it was probably motivated by the fact that he had some videos where there were a bunch of topless girls running around, and I think that they were trying to. I think that was the real motivation, but I didn't read the proceedings, and I'm just judging from the outside. So
Right.
yeah, I don't know if anything comes to mind that you'd like to remark about that before we move on, but
Well, I think, yeah, like I think the challenging thing too is that, there's every day more and more music is created. And, there's only so many things that can be done that are unique. And you listen to one song, you think, oh, this sounds similar to something, I've heard before. And it becomes more challenging for a new artist to come up with
mhm,
something that, when you think of, say, different rock bands or just different, just over the years and things that they used to sound very unique. And it's a struggle. And I don't know what point we reach that point where, there's no empty space available to, stake out a really unique sound, beat, elements of songs,
mhm.
because people have been, inspired by so many artists, and it's hard to get that out of their head maybe when they're writing music or experimenting.
And with fair use, sampling has been a thing for ages. Like the one I always think of is the Police tune. I'll be watching you, turning into that P Diddy Puff Daddy song. With the Every Breath You Take. That whole one. There's that guitar line in there, and it's just because it's a one piece of the entire puzzle. They get the rights to that, and it's a brand new song. So off of that idea, that's what made me go. It's like, okay, well, if it's publicly available and you only use a little itty bitty bit, and you're making a very obviously new creative work, as long as you don't make anybody too mad, like it should be like on paper, it sounds like it checks the boxes, and that's included in some of the things that I've done. So specifically, here's the stuff that I've done that might get me in trouble or something like that, which is you're aware of the Cameo service, I'm sure, where you can get certain celebrities to do like a shout out or something like that.
Yeah.
And I knew that like when they first opened, they didn't have it figured out that they should be charging businesses and corporations one price and then everybody else another, right? So, but then they figured it out, and now it's like an extra, like $500 per person, different things like that. So, but what I did instead is I didn't pay for it with corporate money. Instead, I used my own money, and I made sure that they were sending the message to me. Okay, and I know that Cameo gives you the ability to put that all online, and it's public. It's perfectly fine. As a matter of fact, their website is public, so that you can see it that way as well. But if you so do you think that a celebrity, if they give you a shout out saying like happy birthday or something like that, do you think that there's any use of that could still be covered under fair use without just being on the wrong side of that slippery slope?
Well, I don't like to talk in absolutes, right, in the,
Yeah.
in the legal world. So,
Mm.
I'm sure there's some situations where they would object to it being used.
Mhm.
If you're just getting a happy birthday and you put it on your Facebook or your LinkedIn page, or something like that, that it probably is fine. But if it's used in other areas or in other ways, or posted on other sites that are objectionable, or that the celebrity or maybe your Cameo or both, or maybe the celebrities PR people and their management don't like it, or even maybe to go farther, maybe even some of the things they're involved with, maybe their studio, their sponsors, things like that. It might be, something where, yeah, there could be a problem and they might not want that association. So it might even extend beyond the copywriting of it. It's just the usage of it in a, what they deem to be an inappropriate way.
Okay, that makes sense. So, what I did, like one of the things, I think Gilbert Gottfried is probably the best example as far as myself. So he ended up, I got him to troll me because I was concerned as a digital guy who's like super duper boring. You know, I didn't know that I'd get this far into the entertainment side of things, but I was going like, okay, well, I didn't really want some troll to come around and mess with my business by just talking smack. And so the strategy I was doing based on a black hat SEO technique is I'm going like, well, if you've got a troll saying something awful and then you got Gilbert Gottfried saying something way worse, nobody will remember what the troll did, right? So, you know, like I've got him going on. It's like, I have no idea who he is. I don't even know how to pronounce his name and all that kind of stuff. And so I've looked for some other ways to use that clip. And now that, because Cameo, they let you post it on your social media. You're allowed to post it on your Facebook. Obviously, you wouldn't be allowed to post it on, you know, hey, you know, buy from my McDonald's. Here's Gilbert Gottfried. That is quite clearly not the intention of what is out there. But since I, you know, did what I was allowed to do in making it public, now there's a public video of somebody saying my name. And then if I just put that into something that represented my business, that would not be okay. And I get that. But what if, I got a new series where there's no money that changes hands. All I'm doing is basically documenting conversations that I have with commercial real estate investors. Okay, I'm publishing onto YouTube, and it's got a little sizzle reel thing at the beginning that a lot of people are going to think are quite boring. Okay, but what I was doing is because I've also got a series of fully digital AI avatars, including one of myself. What I do is I include some clips of my AI avatars inside the sizzle part. And then I use clips of real people. And then there's a little sub contest in these episodes saying, hey, you know, go ahead and comment with the time code with the one where you see a fake human. So you have to have some real humans. You have to guess which ones were actually robots and which ones were actually real. So how bad do you think I stepped in a hornet's nest on that one? Because, like, to tell you the truth, I'm fully prepared to take them all down and remove that part of it. But I think that for a short time, giving it a try as a gimmick, you know,
Well, you know, without seeing it, everything, it's, you know, kind of hard to, you know, describe, but, you know, for me to envision, I guess, in other words. Yeah, I think, yeah, you know, again, I'll answer it in a lawyerly way. I'll say, well,
what's
you know, I'll
up?
have
I'm
to,
Dan Frayden. Okay, cool. Well, what I can do is I can show you one, just because
yeah, why
it's so
don't you?
funny. Okay, I'll share the screen right here. The sound quality of the music is pretty bad when you share a screen. But let me see who's in. Okay, yeah, I'm. Oh yeah, this is a good example. This is another chance encounter. Hey, what's up? I'm Dan Graham, commercial real estate guide. I'm from the internet. It's time to take your ass on another kind of trip. Cause you can't have the hop if you don't have it.
Not Dan Friedman. I don't know anything about testing online phone.
And stop. So you've already seen a robot, and you've already seen somebody who is a celebrity.
Right. Yeah. You know, I don't know. I mean, to me, this is kind of, it's edging towards that, you know,
Yeah.
maybe not permissible use of it, I think.
Mm-hmm.
But, you know, again, it's kind of, it's a gray area. And that's where a lot of, you know, that's where lawyers try to, you know, that's where we kind of inhabit, right, is the gray areas, because people don't usually do things that are, they either do things that are, you know, blatantly perfectly fine to do, or they, you know, do things that they shouldn't do by any stretch. And, you know, most people have, you know, things that kind of inhabit that area in between. And so, yeah, I mean, even though there isn't, you know, this isn't a monetization kind of thing,
Right.
you know, it could be something that, you know, they might flag and say, hey, this isn't appropriate. Again, I don't have a lot of particular experience with Cameo, but I think it's, if they're looking at for like happy birthday wishes versus, and I was talking about, Steve Boomer was talking about fixing funnels. So I mean, does this have anything to do with commercial real estate? Like, I guess if you were using it in more of a fixing funnels, related promotional thing, because he said those words, and I think he would, understand a little bit about that. Then it might be, better. But I think putting it in there, I don't. It's a gray area. They may object, they might not.
Right. So, well, would you recommend taking it down? I guess you should probably say yes, right?
Well, I'm not your counsel, so this is just a personal opinion. But to me, I think it's a little, I think if you don't want to have a problem, then not having it in there, will avoid any opportunity of a problem. So if you put it in there, then the risk meter starts to climb. And then you might get a notification from them or from someone that, hey, maybe this shouldn't be in here. We don't approve of this use of this video.
Yeah, that makes perfect sense. But what I think you can see what one of the bigger things I was up to is I just wanted to see if I could make something a little bit more entertaining that tends to be a little bit more dry. And it's the biggest thing is I'm happier including them in this sort of situation than I am in something that's actually for straight business. Because what I'm going off of is the golden rule, okay, and the Lao-Tzu version of the same one, right? It's because they do they in Chinese culture they do the negative version. Instead of saying do unto others as you would have them do unto you, it's don't do unto others as you wouldn't have them do unto you. And I find if you combine those two, you're in pretty good shape as far as both ethics and just not making people angry. And that's what I don't want to do. I do appreciate the fact that these celebrities went through and put in the time, even though they were compensated for it, to actually reach out, especially because I got some of them to do really ridiculous things, like Steve Gutenberg there, getting him to complain about getting calls for Dan Friedenberg. It's like, it doesn't even sound the same, right?
Right. No, that's funny. Or you're gonna say with Gilbert Gottfried, saying I never heard of this guy. I get it if you're doing an intro and you're saying you're an expert in this area, but then you have, but maybe not everybody knows about my expertise. And then here's his clip. It's a bit more of a humor thing. It's kind of used in the same vein. So, again, it's where that risk meter, is bouncing.
There you go. So, so thanks a lot for discussing this. I hope it was valuable to the audience as far as, entertaining and giving some neat ideas as far as where to draw the line. Like my clients, I wouldn't really recommend they go for this sort of approach. I think that transparency is the best thing, but this is just a little thing for at least a short term where I throw it in. Like I know that little sizzle bit, it's too over the top, because I'm like pointing at buildings and I'm not really, giving any. There's nothing in there that's actually giving value. It's just like fireworks and all that kind of stuff, even though it's tongue in cheek. But when it comes to intellectual property, clients and whatnot, I know the lawyers that I've spoken to, their biggest complaint is that people wait until it's way too late to actually talk to their lawyer. So obviously people should be talking to you guys sooner. But can you please describe, like the type of client who's a good fit that you think that you could help them more than other types of clients?
Well, thanks, Dan. I think, based on my experience, having been in-house and, been in law firms and a law firm currently, I have a lot of unique experience, both on the patent and trademark copyright side. So, I like working with, clients that are engaging and looking to avoid problems. I think like you said, that's often when, legal counsel are called after they get a nasty letter or worse. And, it can be, more expensive to handle and solve and try to resolve those problems. Where if you bring someone in, like me or another IP professional ahead of time to, work through what you're doing on the marketing side, or if you're coming out with new products or looking to protect your brand names and product names and so forth, you know, at an early stage, so that you avoid these problems. It's really less costly in the long run, and it also is less stressful. And I think even most importantly is it saves time. I mean, time is the most, you know, valuable resource. And, you know, in marketing in any field, you cannot buy time. And if you can, you know, save 6 months of legal headaches by setting off on the right foot, then, you know, it's just a much better situation. And, you know, I talk to clients all the time, and, you know, they really wish if they had resolved something much earlier, or, you know, done something differently. They could have gotten to market sooner. They could have sold a lot more product. They could, you know, be in a better position. And, you know, like I say, time is the most valuable resource.
That makes a lot of sense. That makes a lot of sense. So, and then the other thing is the best way to reach out to you. We met through LinkedIn, and I know that that's a great way to do it. But as far as like websites or whatever, what's the best way to reach out to you?
Sure. Thanks, Dan. Yes, I have a website, patentbaron.com, and you know, that's a good way to you know, reach out to me through the website. And you know, there's all contact information there, and also through LinkedIn as well. Those are two really good ways to reach me.
Awesome. Awesome. Thank you very much for joining today. This has been another interview, another expert interview with Figure It Out. So we'll see you again soon. Make sure you hit like and subscribe and comment. If you have any questions, we'll be sure to take a look and get the best answer that we can for you. But the reason why you want to subscribe is because that way YouTube pays for this stuff instead of me. Okay. Also, it doesn't mean that you're just going to get bombarded with my face and my content. It just means if you do go onto YouTube, my video might be on the list of your suggestions. So most people, they're just searching for, you know, how to change the tire on their car or whatever, and that stuff doesn't really get in the way, but it definitely helps out. So please do hit like and subscribe, and we'll see you again soon. All right, thanks.
Thank you.
Okay.